the basic rules on rest breaks are for every 4 hours or major portion thereof, the employee is entitled to no less than 10 minutes of a rest break. It should be somewhere around the middle of that period. So it's sort of like every 2 hours, they're going to get a break, either the rest break or then they go to lunch, they get another rest break. Well, it used to be until December that you could require your employee to stay on site. You could require your employee to be somewhat available if they had any emergency situation that came up. And this case involved a security guard company where the security guards were required to carry a pager or a radio during their breaks. And even though they were not actually interrupted, the purpose of that was in case something happened. Well, the California Supreme Court said, well, they were not sufficiently relieved of duty. So this is a big deal. And even though they acknowledged that the Department of Industrial Relations has opinion letters and rules that say, hey, you can require someone to stay on site, the court didn't exactly endorse that either. They said, well, as a practical matter, if someone wants to go take a walk, 10 minutes is such a short time that they probably just stay on site anyway. And they did not address the fact that rest breaks are paid and meal breaks are not, but decided to treat the rest breaks exactly as meal breaks in terms of what you can and cannot require your employee to do. Obviously, with a meal break, it's on the employee's own time. You're not paying for it, so you don't have a right to even keep them on site because now you're exercising some control over that employee. Well, they've adopted a similar rule in this case. There are still some things that are unsettled by this case, including, gee, they mentioned your employee can go for a walk, but they didn't say you can require, and that would mean the employee probably will stay on site. But they didn't address, can you require the employee to stay on site? So as a practical matter, we're going to see some litigation over this. And we do have in your materials on page 2 some practical suggestions. You may want to take a look at those to review your rest period policies. And also it's good to have some things in place to make sure that you can account for whether or not people are taking their rest periods. If they miss one, you have to have a way to know it because it's not going to show up on their time card. So you may need to dial back some of these policies. It's definitely something you want to look at. I don't know if John has a comment.
Yeah, a few other things. The problem with that security guard case is that if they had just said, have your pager with you and passively monitor it, and if something happens, come back, deal with it, and then take another 10-minute break, they might have won. But the problem, because they won at the appellate court, they reversed the trial court, and then the Supreme Court said, no, it's not a break, $89 million judgment. And the problem was that they said, well, when you passively monitor your radio, that's great, but it's a shopping center, so when you walk around on your break, if you can kind of keep an eye on the parking lot in case somebody's breaking in, and can you kind of keep an eye on this and that, and suddenly now they're really not on a break. And I think if they had just said, passively monitor your radio, can do anything else, they might have won that case. So now we have a bad law based on some bad facts, and that kind of screws everybody. I still think you can say, look, it takes too long to get down to the convenience store. You got to take your break on site, but we are putting in writing, and I'm doing this now with a bunch of clients, you are to do nothing, you do not monitor anything, you don't stand by your phone, you don't watch the machine, you do nothing. And that's going to be a problem where you've got a single person who's watching a machine, like at a mining operation I've got going on. Yesterday we were talking about. Nevada specifically has a rule that says for both meals and rest breaks, our rules do not apply to a single employee site. Well, we don't have that in California, so we're stuck. And the other thing that you have to check your handbook, and this is what killed the Brinker case about 4 years ago or 5 years ago now that you might remember, where the court ruled, and it was a great result that said companies no longer have to force their employees to take their meals. They just have to make them available, just like rest breaks. It's still a good idea to say you got to take your rest break. But what killed Brinker, the restaurant company with 44,000 employees and this great employer victory, they ended up paying $57 million to settle that case. Why? Primarily because their rest break policy was screwed up. It said 10 minutes for every 4 hours, but it did not say 10 minutes for every 4 hours or any major fraction of 4 hours. And that's anything over 2 hours. And people forget, if you have a 10-hour and 15-minute workday, not including meals, but you actually work 10 hours and 15 minutes, that's 3 rest breaks. 4 hours, and then 2 hours and 15 minutes is 3 rest breaks. So you've got to remember that or any major fraction language. And then one other point on this whole area of meals is you've got to make sure your employees are starting their meal by the end of the 5th hour. And there's always confusion about what's the end of the 5th hour. And the simplest way to say it is to use an example. If their day starts at 7 a.m., they got to be eating by noon, 11:59 or noon at the latest. That's the end of the 5th hour, because I have clients saying, oh, we're in compliance, we take our meals at 12:30 in the middle of the 5th hour. Well, that's not the 5th hour, that's the 6th hour. So check your policies, and if you have employees going over 10 hours, they can waive that second meal, but it's a good idea to have a waiver in place. And be careful about having employees signing a meal break agreement, which is on duty. That's an entirely different thing. It can only happen in certain situations where they can't be relieved. And unlike rest breaks, meal breaks can be agreed to be done on duty in certain situations. But there's some very specific rules about that we won't get into now. But there's no waiver allowed or agreement allowed for rest breaks. And this is where the disconnect comes. Your handbook has it clear, and you all understand it, but your leads or your supervisors don't get it. And I can't tell you how many times I meet with the HR director or the owner, and they say, well, this is what we do, it's in our handbook, and we take our meals by 5 hours, we do the rest breaks properly, and then we go talk to the leads, and they go, well, no, we usually skip the second break because the guys vote that they don't want to stay out of the job that long, and so they vote to not do it. Or, well, the machine has to run for a certain time, so they sit there and eat their lunch by it, but we have them clock out. Or we just deduct for a half an hour because we know they're taking their break. So you've got to indoctrinate your leads and your supervisors so they're clear about what's going on, because they're the ones that will mess you up every single time. That's what we see a lot.